Ever wondered what happens when a seemingly straightforward legal case suddenly goes off the rails? You see it in movies all the time. A surprise witness, a piece of evidence that appears out of nowhere, or a key player changing their story. But how do lawyers handle these curveballs in real life? It's not always as dramatic as Hollywood makes it seem, but it is a masterclass in strategy, quick thinking, and adaptability. Today, we're pulling back the curtain to show you exactly how legal professionals navigate the twists and turns that can make or break a case. First, let's talk about the initial shock. When a complication arises, the first thing a good lawyer does is not panic. Instead, they pause, take a deep breath, and analyze. What just happened? Is this a minor hiccup or a major earthquake for the case? The key is to assess the damage immediately. For example, if a key witness for your side suddenly becomes hostile or changes their testimony, the lawyer needs to understand why. Were they intimidated? Did they receive new information? Or were they not being entirely truthful from the start? The first step is always diagnosis. They gather all the information they can about the new development. This isn't a time for assumptions. It's a time for facts. They'll talk to the witness, if possible, review documents, and consult with their team to get a full picture of the new landscape. Once they understand the problem, the next phase is strategy adjustment. No legal case has a single, rigid path to victory. A lawyer's initial strategy is more like a detailed roadmap with several alternate routes planned in advance. When a roadblock appears, they don't just stop. They consult the map for a detour. This is where their experience and creativity really shine. Let's say a crucial piece of evidence is suddenly ruled inadmissible by the judge. The lawyer can't use it anymore. So, what's plan B? Can they establish the same fact through another witness's testimony? Is there a different document that can prove the same point, even if indirectly? They might file a motion to reconsider the judge's ruling, arguing from a different legal angle. Or they might pivot their entire argument to focus on other strengths of the case that do and rely on that specific piece of evidence. It's like playing chess. You might lose a powerful piece, but you can still win the game if you adjust your strategy and leverage the pieces you have left. Communication is absolutely critical during these moments. A lawyer's duty is not just to the court, but also to their client. When a complication hits, one of the first calls a lawyer makes is to their client. They explain the situation clearly, without sugarcoating it, but also without causing unnecessary panic. They'll lay out the new reality, what it means for the case, and what the proposed new plan is. This transparency builds trust and ensures the client is part of the decision-making process. The lawyer will present the options. We can challenge this new evidence, which will take time and resources, or we can adjust our strategy to work around it. Here are the pros and cons of each approach. This collaborative process ensures that the client feels in control of their own fate, even when things feel chaotic. Keeping the client informed and involved is paramount to managing the stress and uncertainty that comes with legal battles. Another powerful tool in a lawyer's arsenal is legal research. The law is vast and complex, and there's a precedent for almost everything. When a novel issue arises, the legal team dives into case law, statutes, and legal treaties. They're looking for similar cases from the past. How did other courts handle a witness who recanted their testimony? What are the rules for admitting a last-minute piece of digital evidence? Finding a previous case with a similar fact pattern can provide a ready-made argument or a legal pathway to follow. This research can uncover procedural loopholes or substantive arguments that can turn a complication into an opportunity. For instance, if the opposing side introduces a surprise expert, the lawyer will immediately research that expert's background, previous testimonies, and publications, looking for inconsistencies or biases that can be used to challenge their credibility during cross-examination. Let's not forget the power of negotiation. Sometimes, a major complication can actually create an opening for a settlement. Perhaps the new evidence weakens your position, making a trial riskier, or maybe it weakens the other side's case, giving you more leverage. A skilled lawyer knows when to pivot from a trial footing to a negotiation stance. They might approach the opposing counsel and say, "Look, this new development changes things for both of us. A trial is now more unpredictable for everyone. Let's talk about finding a resolution that we can all live with." This is not a sign of weakness. It's a strategic move to protect the client's best interests. A good settlement can be far better than a risky trial, and a sudden complication can be the very thing that brings both parties to the table. Ready to make a deal? It's all about re-evaluating the risk-reward calculation of the case in real time. Sometimes, the complication isn't about evidence or witnesses, but about the people involved. A client might become difficult, or the relationship between the lawyers on opposing sides might become strained. In these situations, a lawyer has to be part psychologist and part diplomat. They need to manage their clients' expectations and emotions, keeping them focused on the long-term goal. With opposing counsel, even if things get heated, maintaining a professional demeanor is crucial. Burning bridges can backfire. Today's adversary might be a potential ally on a different case tomorrow. Moreover, judges and juries are very perceptive. They notice unprofessional behavior, and it can negatively influence their perception of a lawyer's case. So, even when faced with frustrating tactics, a great lawyer keeps their cool and sticks to the facts and the law. Finally, let's talk about the unsung hero of handling case complications: the legal team. It's rarely just one lawyer against the world. Behind the lead attorney, there's often a team of paralegals, junior associates, and legal assistants. When a crisis hits, this team goes into overdrive. Paralegals might be tasked with tracking down new documents. Associates might be assigned to research a specific legal issue around the clock, and assistants handle the logistical nightmare of rescheduling and This collaborative effort allows the lead lawyer to focus on the high-level strategy and courtroom performance. The ability to delegate effectively and trust the team is a hallmark of a successful attorney who can weather any storm. It's a well-oiled machine designed to absorb shocks and keep the case moving forward. So, the next time you see a courtroom drama where everything goes wrong, remember that, in the real world, it's not about a single moment of genius. It's about a systematic process. Assess, strategize, communicate, research, negotiate, and collaborate. It's the combination of preparation, experience, and a cool head that allows lawyers to turn potential disasters into manageable challenges, and sometimes even into unexpected advantages. It is a testament to the fact that the practice of law is as much an art as it is a science. Thanks so much for watching. If you found this glimpse into the world of law interesting, please hit that like button and subscribe for more content. Let us know in the comments if you've ever wondered about a specific aspect of the legal process, and we might just cover it in a future video. See you next time!